Hello friends, welcome to Abhinav Goswami Law classes. So friends, in this video we are going to discuss section 33 of Indian Evidence Act, a very interesting and very important yet not so hard section of law. So friends, please open your Bear Act, open section 33. So section 33 reads, relevancy of certain evidence for proving in subsequent proceeding the truth of facts therein stated. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of the facts which it states when the witness is dead or cannot be found or is incapable of giving evidence or is kept out of the way by the adverse party, or if his presence cannot be obtained without an amount of delay or expense, which under the circumstances of the case the court considers unreasonable. Okay friends, so this is the main area of section 33. So what is it that section 33 is providing for? So what we are going to do, we are going to divide the section into its parts and we will see what are the basic requirements and purpose of this section. The first thing that you must understand is that section 33 is talking about such a evidence which was given at a prior stage. And what we are trying to do now, we are trying to see that how valid that previous evidence is in this new judicial proceeding that had started. Okay, so with this in mind, we will start to demarcate the ingredients of the section. So the first thing that is required for the application of 33 is, or section 33 is that evidence, the previous evidence which we are wanting to apply in the present proceedings was given in a judicial proceeding. Judicial proceeding. So underline this term. This is very important that the evidence which was given by the witnesses was given in a judicial proceeding. So if for example a particular evidence was given by a particular person, particular witness in a administrative proceedings or quasi judicial proceedings, it will not suffice. They have to be judicial proceeding per se. First requirement. Okay. Second is, or before any person authorized by law to take it. Now comes the broadness of the section. So when we use the term judicial proceeding, we state jacketed section 33 that what are judicial proceedings which happen in courts of law. Okay, but by the second part, by using this term before any person authorized by law to take it, we are encompassing each and every kind of proceeding where evidences are allowed, and there is a particular person who is authorized by law, by a particular law, to take that evidence. So present day modern acts. Okay, so for example, if we say these modern authorities, quasi judicial authorities, they are granted power of civil courts, criminal courts, so as to exercise their powers, right, proceedings, so as to conduct their proceeding in a must manner. So they are also provided with the power to take evidences. So the second part, which says before any person authorized by law to take it, encompasses all these people. Okay, so what are the facts that we learn from this first requirement? That the evidence which was given by a witness was in a judicial proceeding or before any person who was authorized by law to take it. Okay, this is the first point you need to remember. Now this statement, this evidence that we are talking about, which was given in a judicial proceeding or before any person authorized by law, this statement or evidence is becoming relevant in a subsequent judicial proceeding. So the second important point that you must remember about section 33 is there are two proceedings: prior proceeding and subsequent proceeding. Evidence was given in a prior proceeding, where we are trying to apply it is in a subsequent proceeding. So the second point that you must remember is that we are looking at the relevancy of this statement in a subsequent proceeding. Okay, so this evidence is not being given in this subsequent proceeding. This evidence was given in a prior proceeding, and now we are trying to apply those evidences in a subsequent proceeding. So the second point is that this we are looking at the relevancy of this evidence in a subsequent proceeding, okay, or in a later stage of the same proceeding. Very important that you understand this. So as far as the second part of second requirement is concerned, which says in a later stage of the same judicial proceeding, it means that the proceedings are the same cause of action, same parties, everything is same, not same case number, everything, but it is at a later stage of a judicial proceeding. So what will be the example of this? For example, a particular judicial proceeding was decided ex parte, for example, and for deciding it ex parte means in the absence of the other party. Okay, if a particular proceeding is decided ex parte, so whatever evidence was taken at that proceeding when it was decided ex parte, and in future if the other party comes before the court of law and makes an application for setting aside that ex parte degree and conduct the full blown trial. So in this is what, if trial is allowed, ex parte decree set aside, this is the same judicial proceeding, it is not an independent judicial proceeding. So at the later stage when ex parte decree set aside and and the full blown trial is going on, in this proceeding these evidences which were given when ex parte decree was being decided can be made relevant as per section 33. So these ex parte decrees, cases of ex parte decrees and setting aside of ex parte decrees can be an example of those cases where these evidences given in the same proceeding at the earlier stage can be made relevant in a later stage. And as far as the first part is concerned, which is about the subsequent judicial proceeding, it means an independent judicial proceeding. Okay, this was a separate case and subsequent judicial proceeding is a separate case. Okay, now we have covered two important points. Third point is that this evidence which we are accepting in a subsequent proceeding or at a later stage of the same proceeding, this person who gave the evidence should not be available before the court of law. So this requirement of non-availability of section 33 is of same nature as provided under section 32. In section 32 also, the person who made the statement was not available before the court of law to prove its validity. The same is happening in section 33. The person who gave the evidence in the previous proceeding or at the previous stage of the same proceeding, he is not available anymore. And there, what can be the reason for his non-availability? That he has died, that he cannot be found, that he has become incapable of giving evidence. For example, he became a person of unsound mind, or he is kept out of the way by adverse party. It may happen that the party against whom this person deposed is making all the efforts so that this person does not come. So if this is a case, then also his previous evidence can be relied on. And finally, if his presence cannot be obtained without an amount of delay or expense under the circumstances of the case, the court considers unreasonable. So the presence can be procured, but it will involve high degree of expense and delay. That is why the court is considering it reasonable to call that witness. So in all these circumstances where, because of which the person who actually gave the evidence in a prior stage of the same proceeding or prior judicial proceeding can be admitted as, can be made relevant evidence in the subsequent proceeding. Okay, friends. So I will do a quick review. Don't get confused. I'm trying to clarify each and every point. So the first point before you need to remember is that the prior evidence was given in a judicial proceeding or before any a person authorized by law to take it. So second part is the broadest part. Okay. Second, the evidence which was given in any prior judicial proceeding or any person authorized by law to take it is being made relevant in a subsequent judicial proceeding or at a later stage of the same proceeding. So there is a difference of prior or subsequent proceeding or prior stage or later stage of the same proceeding. And finally, the person who had given the evidence at the earlier stage of the same proceeding or at an earlier judicial proceeding is not available before the court of law for any of the 5 reasons that are mentioned. These are the 3 things that you need to remember. This is what section 33 talks about if all these three requirements are satisfied, the evidence which was given in the prior judicial proceeding or prior stage can be made relevant at this stage of subsequent judicial proceeding or at a later stage of the same proceeding. Now come to provisos. Provided that the proceeding was between now this provides, we have already understood the 3 points, the three main basic requirements. Now we are going to look at what are the other requirements. Proviso says that the proceeding was between the same parties or their representative in interest. So for the application of section 33, one more requirement is there, that is the fourth requirement. What is that requirement? That the prior proceedings or this subsequent proceeding has to be between the same parties or their representative in interest. So the parties has to be same in the prior proceeding and in the subsequent proceeding. Only then the evidence which was given in the prior proceeding can be made applicable, can be made relevant in the subsequent proceeding. So what is the fourth requirement, friends? Identity of parties or representatives in interest. Okay. What is the fifth requirement? That the adverse party in the first proceeding had the right and opportunity to cross-examine. This fifth requirement is very important. Only those evidences of prior proceeding will become relevant for subsequent proceeding where in the prior stage, when this evidence was given in the prior proceeding, when that evidence was given, the opposite party against whom that evidence was being given had the opportunity to cross-examine the other party. So we are talking about opportunity to cross-examine. We are not saying that he had actually cross-examined. No, cross-examination of that evidence is not necessary. But what is necessary is that the other party had the opportunity to cross-examine. The court gave the other party the opportunity to cross-examine. Okay, whether he conducted cross-examination or not is a completely different matter. Okay, friends. So if there was an opportunity to cross-examine with the other party, only then the prior evidence given in the prior proceeding can be made relevant for subsequent proceeding. So these two additional requirements have been added. Now come to the last requirement, that the question in issue were substantially the same in the first as in the second proceeding. So final requirement, the sixth requirement, is a great limitation. It is saying that the questions in issue, the main disputes, have to be substantially same. They need not be identical. There may be a bit of change in the disputes. There were, for example, in the prior proceeding, there were 2 disputes. In the subsequent proceeding, there are 3 or 4 disputes. But they have to be substantially same. So the fact in issue in the case must be substantially same. So what are the 3 additional requirements that this proviso provided, friends? First was same parties or their representative interest. Second was opportunity of cross-examination. And third was substantially same questions in issue. Okay, friends, 3 additional requirements provided by this proviso. And explanation is a simple explanation. It says a criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused within the meaning of this section. So for example, friends, in civil cases, there is a clarity that who are the parties. Okay, both are individual private members. But in criminal cases, state is one of the party, right? So in criminal cases, the prosecutor and the accused person, they are considered to be the parties. And when we are looking at this requirement of that the parties has to be same, we will look at the whether the prosecutor, we are not saying that the same person. Prosecutor means the state. Okay, so that prosecutor and the accused person are the same. We are not talking about an individual prosecutor, an individual public lawyer. No, prosecutor means the state. Okay, so this is what section 33 is. We will do a quick review of all the 6 requirements that we covered. First requirement is that the evidence in the prior proceeding was given, which was the proceeding was a judicial proceeding, or it was given before any person who was authorized by law to take it. This is the first requirement. Okay, the second requirement is that the subsequent judicial proceeding or that this evidence, which you are trying to make relevant, is being made relevant in a subsequent proceeding or at a later stage of the same proceeding. So this statement, which was given in a judicial proceeding or any person authorized by law to take it in a prior proceeding, and where it is being made relevant in a subsequent proceeding. So the second important point is subsequent judicial proceeding or later stage of the same judicial proceeding. Finally, the person who had actually given the evidence in the prior proceeding or prior stage of the same proceeding is not available before the court of law for any of the 5 reasons that are mentioned. These are the 3 requirements which were provided by the main part. Now, additional 3 requirements were provided by proviso. What were these 3 additional requirements, friends? That the prior proceeding and the subsequent proceeding, prior stage or the later stage, obviously, they has to be between the same parties or representative in their interest. And fifth requirement was that when the evidence was given in the prior proceeding or at the prior stage, the opposite party had the opportunity to cross-examination. So fifth requirement is opportunity of cross-examination. And finally, the sixth requirement, and I think is one of the greatest limitation for the application of section 33, is that the questions in issue should also be not identical, substantially same. Okay, these are the 6 requirements of section 33, and which makes section 33 very, very important for you. Okay, friends, with this I will close this video. I hope you understood section 33. Friends, if you want to appreciate my efforts, please subscribe to my YouTube channel. And friends, if you want to connect with me on Telegram, the invitation link to my Telegram group is pasted in the description of this video. You can click on that and connect with me. Until then, friends, be safe, be happy. Bye bye. I'll see you very soon.